Good afternoon and welcome to Oklahoma Realtors' second town hall meeting on the new buyer broker agency agreement that is coming into play, or should I say being continued in the state of Oklahoma under new context. I'm Bryan Hutchinson, and this is Jace White, our legal counsel, joining us today. And this session is all about answering your questions. Our format today from our last town hall, we had, I think, Jace, somewhere in the neighborhood of 50 or so questions.
I think about 90,
that many
questions, yeah.
We've taken those questions and broken them down, brought them into some smaller categories that we're going to try to deal with today. And then, of course, we're going to be taking your questions live as well. Now, to ask a question, what we're going to want you to do is go to the Q&A or the chat section on this Zoom. And if you'll type your question in there, we will refer to those as we're going through this presentation today. Will Gattenby, our Chief Operating Officer, will be feeding those to us. Our time limit for today is 1 hour, so we won't take more than 1 hour today. And if we need to come back or create some more resources for you, we absolutely will do that. Jace, everything safe before we get going?
No, just other than I'm happy to be here, happy to be of service to all of you. And again, a quick plug right before we get started. We're going to be taking up a lot of questions today. I'm sure that not all questions that are out there are going to be asked today. So just as a brief plug at the beginning, if you've got additional questions that aren't covered today, send us an email at legal@okrealtors.com and we'll be happy to help.
Right. And the last caveat with that is to remind you that we're not here today to provide legal counsel or legal advice, rather just help you get a good understanding of this agreement, answer your questions. Always, always, always refer back to your broker. Now, I've asked Krista to hand me a handful of documents that I haven't gotten yet. Thank you, Krista. And Jace, with that, let's kick it off. Under paragraph 7, compensation, one of the questions that was repeatedly asked is what type of compensation arrangements can be made? What are the different types of compensation that can be used in paragraph 7?
Sure, and I just want to provide some clarity. I think some of the confusion about paragraph 7 that's out there right now is, can we use a combination of different types of compensation? I would say that so long as you're complying with the outer rubric, I should say the outer guidelines of NAR's settlement practice changes, then you should be fine to do that. So under paragraph 7, you can choose to get paid in a number of different ways. That can be a flat fee. It can be a percentage of the final sales price. It can be you can work off a retainer fee. There's language built in there to utilize a retainer fee, or you can use a combination. If you want to charge a flat fee plus a percentage of the final sales price, you're allowed to do that under paragraph 7. The issue here is that it cannot be open-ended and it must be objectively ascertainable. One of the hypotheticals that's been asked of me is, well, can I put, it's the amount of compensation I'm receiving, can I just say whatever the seller's offering? I think that would be the classic example of something that's open-ended and would not be allowable under NAR's practice changes.
Yeah, to further hone down on that, by the way, I want to remind everybody with paragraph 7 that all compensation is negotiable. Negotiable means that there are 2 or more parties coming to a meeting of the mind. And so whatever you agree on, you agree on. By the way, a buyer may want you to work for less money than you want to work for. That's your choice. Again, compensation is negotiable. Jace, along the line, I got asked a question. What about in kind? For example, we have in some areas people who do in kind compensation. So instead of getting paid a dollar amount or a percentage, they get an object in exchange. Like, you represent me on this transaction, and for a quid pro quo, I'm going to give you, I don't know, 1957 Mercedes 300 SL Goldwing. I would do that real estate deal in a minute. But anyway, what about in kind? Is that allowable under paragraph 7 as long as it's spelled out?
As long as it is spelled out, it's objectively ascertainable. It is most assuredly allowed. I think to Hutch's question, the only question you run into there is, if you're distributing that compensation as a broker to an agent that maybe worked on the transaction, you could run into division issues there. But the legality of it's perfectly permissible. And if you're working one as a solo practice broker, yeah, absolutely.
Yeah. Okay. Good.
Yeah, absolutely. So let's shift over to question number 2 here. Okay. Hutch, this is for you. How are buyers brokers going to learn in the first place whether cooperative compensation is even being offered?
Great question. So compensation in all forms comes out of the MLS, can no longer be there after August 17th for an MLS that's opted in, which I think every MLS in the state of Oklahoma has opted in at this point to the settlement agreement. Let me first tell you how you shouldn't try to obtain what that compensation is. You should not try to obtain it through the MLS. You should not try to obtain it through a workaround. I know that there are a lot of websites that are popping up right now where, like stateyourcommission.com or something like that, where they're creating these offers for agents to come in and to list the compensation they have for the different properties collectively together. Please stay away from those things. Counsel at every level to our association conversations has warned us about those. We know that parties on the plaintiff sides of these lawsuits are watching social media, are watching those kind of websites. They're taking notes. We're not going to see the big fallout of those type of sites now. We're going to see them in about 7 years. When the settlement coverage comes to a close and they go back and say, oh, look at all these things that people did. Stay away from those things. Instead, we know that some brokers are putting their own compensation on their website. So I would encourage you to check brokerage websites and their individual listings or their policies. Pick up the telephone and make a phone call, send an email, or send a text to verify it. I think a bigger question around this, Jace, is not as much how are we going to learn what cooperative compensation it is, but when is it the obligation to learn that cooperative compensation? Like I get that, I've been asked that question multiple times in different associations or offices or places that I've been speaking on this. In other words, do I need to know about that compensation before I go show the property or after I show the property? You want to say anything about that?
Yeah, I think what I would say there is just general best practice. In the name of protecting and promoting your client's best interest under Article 1, the sooner the better. If you're able to ascertain what compensation is being paid out there at the earliest point possible, that can help shape and inform what type of offer your buyer may want to make on that property. So in order for your buyer to be as informed as possible, I would just recommend as early as possible.
I would agree with that. I think good agents, like good practicing agents that really want to provide the most information and the greatest level of choice to the consumer, to the buyer particularly, they're going to try to ascertain prior to showing what level of buyer's compensation may or may not be included in the already marketed property. In the same way that they're going to try to ascertain whether a 4-bedroom home is really a 4-bedroom home, or it's a 3-bedroom home that has a study, doesn't have a closet, but they're trying to cross-market it as a 4-bedroom home, right? In the same way that you try to obtain other information, you're going to try to obtain that level of compensation information so that you can share it with the buyer and then give the buyer the choice whether or not that's a property they want to see based on that, as well as all the other criteria. Biggest key about that compensation part is let it be the buyer's choice. So I would say get the information as soon as possible. Send a text, make a phone call, send an email, always in writing is better. Get it as soon as possible, but then so that you can share it, but always let it be the buyer's choice.
Absolutely.
All right. Let's see if check in with Will, let's see if there's any live questions that we can take at this time. Will?
Oh, guys, you've kind of addressed a couple of the questions that have come in here, and so we've just put that they're going to be answered live. But one question here is about the Zillow touring agreement and other types of agreements that exist out there. And are other types of agreements okay to use beyond just the OREC buyer broker agreement?
Yeah, so the answer to that question unequivocally is yes. There is no requirement in the settlement or in any of the MLSs that I'm aware of that says you have to use a specific agreement. Nor does the agreement actually say that you have to use a buyer's agency agreement. The settlement says that you have to use an agreement, and it's implied that that agreement solidifies the terms, including compensation up front. But no, you do not have to use the OREC form. Now, there's some advantages to using the ORECA form. Would you agree, Jace?
Yeah, absolutely. I think it covers a lot of bases that you're going to want to have covered in order to protect yourself. And again, if you want to make it function more like a touring agreement or a very time-limited agreement, as we talked about on the last webinar, you can use those additional provisions, the additional provisions section in paragraph 15 to specify, hey, this is only for XYZ property, or it's only applies to XYZ circumstances or a geographic area or something along those lines.
Yeah, to me, the OREC agreement and what I think they really got it right. And by the way, I want to applaud all of the people. I mean, that was a lot of people working on that process. What they got right in the OREC agreement was two things. One, they got a tremendous amount of negotiating room. There's a lot of opportunities. You want it to be an exclusive agreement or a non-exclusive, there's room for that. If you want it to be for 1 hour or 1 year, there's room for that. If you want to specify different types of compensation, work off retainers, there's room for that. If there's special provisions for geographical areas or nuances, there's room for that. And so there's a lot of room for you to really customize that agreement based on. I think that's one thing they got right.
Yeah.
Here's the second thing, don't get lost on our agents and our brokers about that form, is that form is generated by the state. And so if there becomes a question about whether a form in its nature is biased towards one party or the other, that's kind of removed. So there's a certain level of protection in using that form. Whereas if you're using a specifically generated form that's only available to a small collective group of individuals, and that form seems to be weighted towards the agency side as opposed to the consumer side, that could create some problems downstream. And whereas the OREC form is incredibly neutral, and is weighted both equally to the consumer and to the agent. So they got a lot right on that form. So no, short answer, you don't have to use the OREC form.
Yeah, no, I completely agree. Back to what Hutch was saying earlier, one of OREC's purposes, one of the goals that they further write is consumer protection. They want to make sure that consumers are protected when they're engaging in these transactions and retaining licensees to help them do so. And so to function off of a form that's promulgated by that entity, I think is incredibly beneficial.
Me too. Will, we have any other questions you want to take right now?
One more question I think fits at our moment here. We're sort of looking at the beginning of this and the OREC buyer broker agreement in general is, what do you do about the buyer's broker agreement if you are showing one of your own listings?
Yeah, so maybe a way to answer that question is to say, pose it in a different way. When do you need to start using that form?
Yeah,
And so, Jace, the settlement language is pretty specific about that, right?
it is. Yeah, no. So what it clarifies is that if you are working with a buyer, you must have a written agreement signed with that buyer before showing them a property. If, again, as we mentioned earlier in the last webinar, if you're showing one of your own properties and an unrepresented buyer calls you, there's a series of steps that you can walk through to make sure you're protected and to make sure you are doing it in compliance with NAR's practice changes. Again, first you'd want to ask that buyer, are you represented or not? If they are represented, then obviously proceed with scheduling that showing with their agent, and you're clearly not working with them. If, however, they're unrepresented, and then the question becomes, do you want to be represented? Are you desirous of representation during that show? And if they are, then that's something that you're going to need to iron out with them if there's an expectation on their part that you're going to be working with them on this to get it signed before going ahead with that showing. If, however, they don't, and they're expected to go through with this just completely representing themselves, then there's no need for a written agreement with them because you're only working for the seller in conjunction with that showing.
Yeah, I think the kind of the down and dirty rule, right? The like, how do I answer this on the fly really quickly? If, as a listing agent, you're representing the seller side of the transaction. You are required to give them your full force and attention. You're required to help them every way that you legally and ethically can to sell that property. That includes showing the property. That includes helping to draft a contract or reduce an offer to writing, things like that. So you are required by the state to engage in some of those behaviors. the down and dirty, the simple thing you need to ask or you need to obtain is clear meeting of the minds with that buyer as to whether or not they are represented or whether or not they want to have representation. If they are represented by somebody else, send them to their agent. If they don't want to have representation, I would recommend getting that in writing somehow, just simply saying, I choose not to have a representation. If they want to be represented and you've explained to them what that is, get a buyer's agency agreement signed with them. Just that simple.
Agree.
Good.
Will, any more before we jump back into some of our other slides here?
You guys jump back into your questions and I'll have a few more for you whenever you have another break.
All right, thanks, Will. Jason, I think question 4, is that for you or for me?
I think we're on 3. I think we do.
3? Oh,
Yeah, I
3.
think we're right there. Yep.
Okay, I'm sorry.
No, you're good.
All right, so question number 3, what is a buyer broker's resource if the buyer fails to close on the property? The listing or the buyer's agency agreement talks about 2 kinds of defaults, a default that's because the buyer and a default that's not because of the buyer. So if the buyer defaults and doesn't close, what's my recourse?
Yeah, I think so at that point, it really becomes a question of practicality, right? Assume exactly like Hutch just mentioned, the buyer fails to close and clearly the failure is a result of the buyer's actions. At base level, under the standard buyer broker agreement from REC, they would still owe you compensation as they would have otherwise owed you at the closing table.
And that's the same as it is today, right?
Yes.
Yeah.
Yeah. So then the question becomes, well, what do I do about it? Like, buyer walks out and I'm sitting here with legal options available to. I think first off, as a broker, you're going to have to make the decision, is this worth it for me to pursue?
Yeah.
I think different brokers are going to arrive at different answers to that question as far as, do I want to be a broker that is going to pursue my legal rights as against a client who had a transaction fall through for whatever reason? Or do I just want to let that go and try to preserve that relationship in the future? I think you're going to get different answers to that question all around. Ultimately, if you do choose to pursue recourse, your recourse is fundamentally going to be in court somewhere, right? If the amount you're seeking that you would have otherwise been entitled to under the contract was 10,000 or less, you could look at filing in small claims court. It tends to be pretty cost effective. A lot of people engage in small claims court without even retaining counsel to do so. Obviously, you have the right to hire counsel to do so. In the event the amount you're seeking is more than 10,000, from a jurisdiction standpoint, you're going to be in district court, and that tends to be a much longer process. And a lot of people can feel overwhelmed in trying to do that by themselves without having counsel. So
Yeah, and to be clear about that, by the way, it's not the amount that you're owed, the amount that you're seeking.
the
The amount that you're seeking determines what type of court of jurisdiction
Right.
you apply to. 10,000 and under in Oklahoma, you're going to a small claims municipal type of court. Beyond that, you're going to district court. And I think it's well said, by the way. This exists today. I want to remind us all, this isn't any different than it is today. If you use a buyer's agency agreement form today, and somebody defaults on it, you have to choose whether or not you're going to seek that compensation or not. This is lost, by the way, among most of our members. Because as long as I've been practicing real estate, which is a long time, I can't think of a single instance, and I've tried, where a broker has gone after a buyer for compensation when the buyer at buyer's fault did not close on a property. I can't think of a single time that's happened. I think that will happen going forward in the future, because now the common practice is going to be to use the agreement. And if you're using an agreement like the OREC agreement, it gives that right and ability to do that. Remember, the OREC agreement in paragraph 2 clearly states that this has to be filled out before a showing can start. And so now the buyer is willingly entering into this agreement, whatever is stipulated. So if it's agreed to in whole, there now is a mechanism to clearly and easily pursue that compensation that would be owed.
completely agree. Hutch, let's jump over to a question for you before we go back to Will with more live questions. There's been a lot of discussion on renegotiation of compensation specifically. Can you renegotiate buyer broker compensation downward or upward, and is there a difference regarding that?
No, the answer is to both of those, yes. Yes, you can renegotiate commission upward or downward. Jace, I had an old preacher that told me one time, he grabbed me up and he said, boy, you can be 100% right and still be wrong. And it took me a while to understand. I had to get a little leather worn off my shoes before I really understood what that meant. And I finally got it one day. And what he meant was, just because you can do something doesn't mean you shouldn't do something, right? Renegotiating compensation is a great example of that. An example of negotiating down, let's say that a buyer really needs compensation to be paid by the seller. You've agreed to some arbitrary number. I'm not fixing commission, but for the sake of being really clear to our members and not just hiding, not trying to fix commission, but let's just say that you agreed to work for 7%. I don't know. And the most amount of compensation you can get is 2%. You might choose to negotiate down to get that job, to get that deal done. Best interest of your client, it meets your needs, you may choose to do that. You may also, by the way, choose not to do that, and it's completely your choice. Let's talk about negotiating upward. The most common opportunity to negotiate upward, I think, is going to be in one of two areas. Area one is going to be that the seller is offering more than you've entered into the agreement for. Let's use that same exact scenario, not because those are market fixed commissions, but because we're just talking those. You've agreed to work for 3%, they're offering 7%, you go windfall, and I want to take that, let's renegotiate this contract and negotiate up. Well, if you're not doing any more work, if you're not putting any more effort into it, there's no justification for that. A case could easily be made that you are taking advantage of your client by accepting that higher commission, even if they agree to it. Because in theory, they may have been able to save that delta, save the difference off the sales price of the house, or got a credit towards closing and may have benefited them somehow. And you could end up in trouble over that. However, let's look at it a different way. Maybe you entered into the buyer's agency agreement form, right? And in entering into that buyer's agency agreement form, you agreed to do it for one day, for one house, that they absolutely loved. And because you thought it was gonna be a super easy transaction with limited amount of work, relatively shored up in less than a 30-day period of time, you agreed to do it for a lower amount of commission than you would usually work for. But you go see that house. That house does not look anything like the pictures that were taken. Not that that ever happens. The house is smaller than what it's advertised to be. Not that that ever happens. The house is no longer available, even though they found it on some third-party data aggregator website. It says it's available, not that that ever really happens. And so now the one house on one day in one small town with a 30-day total project has now turned into 50 showings, and it's going to take 4 months to get done. That might be a great example where you could justify raising the compensation rate to adequately cover the costs and time of cost of actual physical driving around, plus the time, the labor, the resources that go into it. So just because you can doesn't mean you should. And I think the litmus to that is always going to be, is the raise and increase warranted? And is the lowering of commission rate likewise warranted?
Yeah, completely agree with that. Wouldn't change a thing. Hutch, let's go to Will for another short minute for more Q&A. Will, do we have any more questions?
Yeah, we've got a couple here, I think, that actually tie into some of the stuff you guys are talking about. Right here, one from Andrew Schultz here. Is it appropriate for the listing agent to ask the buyer's broker what compensation, if any, they are receiving from the buyer prior to an offer of compensation from the seller or the listing agent to the buyer's broker?
I think I got lost in you reading that question. Did you read that question for us one more time?
Yeah, let me try to summarize it. Is it appropriate for the listing realtor to inquire if the buyer broker, the buyer's agent, is being compensated before they determine whether they're going to offer any compensation?
So I think the two are actually mutually exclusive. First and foremost, the listing agent in offering compensation is doing so with the agreement and the permission of the seller of the property, first and foremost. And so before we get into the specific of that, answering this question, let's clarify that. That the listing agent has, no matter what commission split they're doing, they have to have the permission of the seller of the property.
Mhm.
That hasn't changed. Likewise, the buyer, everybody needs to understand in the answer to the question, the buyer needs to know what the maximum compensation they're allowed to, whether it's a dollar amount or a percentage. From that point of understanding, I think it is a fair statement to say negotiation is negotiation, and in negotiation, information is king, data is king. And so in the same way, a buyer's agent may be trying to find out how much compensation is being offered. It would be fair for a listing agent to also say, is your buyer prepared to pay you your commission on their own? Or do you think they're going to be asking for something in the offering? And then allow that dialogue to go back and forth. As a general rule, nobody in an agency relationship, as Oklahoma defines it, where you're representing the transaction, should be sharing information with the other party that they don't expressly have permission to share. So if a buyer hasn't said, yeah, you can share that data, you shouldn't be sharing that data. You should just simply say that it'll be outlined in the offer that we send to you. Same thing, if the seller hasn't told the listing agent you can share data, don't share that data. And simply stick to the line. We will entertain all offers, even offers that include compensation.
Yeah.
Jace, what would you add to that?
I would say yes, that information is king. That as a general rule, the buyer broker agreement does not have a confidentiality clause in it. And so it contractually, at least, is not inherently confidential. I will say that Oklahoma law allows an agent's client to specifically designate certain information as confidential. And obviously, if a buyer were to specifically designate that as confidential here, then you obviously would not want to be sharing that information. But with no such request to keep that information confidential, I don't see a problem with facilitating that through negotiation. Yeah.
So I guess the short answer to that question would be, yes, a listing agent could ask that question, and no, the buyer's agent has no obligation to share that information.
Yeah, I would agree with that.
Good. Jason, let me fire at you. Go ahead, Will.
I think a couple that might be pretty short for you guys.
Okay.
As you're talking about renegotiating, one term of renegotiation is cancellation. Can this agreement be canceled? And if so, how?
Absolutely. There's a termination clause. I believe it's paragraph 6 of this document. And paragraph 6 allows for termination. I would caution our agents that termination is specifically spelled out, 3 days written notice. And so you can't instantly terminate it and have it terminated unless you both come to the meeting of mind on that termination, which should be memorialized in writing. Otherwise, you're bound to 3 days. You can terminate, or the buyer can terminate it. And you can enter into a new agreement. You could mutually come to a meeting of the mind to terminate it now and enter into a secondary agreement and waive that 3-day period of time. If you're waiving that 3-day period of time, you absolutely must have that memorialized in writing with signatures of both parties, the initials and signatures of both parties. Otherwise, the default is 3 days.
Yeah, agree with that. And again, just to remind you, either party under this agreement can terminate. So that whether that's the broker, whether that's the buyer, each side has that right of termination. And at baseline, right, there's a 60-day protection period built into that paragraph 6 for, if one of those properties ends up being purchased by the buyer, that was shown under the terms and within the time frame of the agreement. And if that occurs within 60 days from that termination, then there's provision in there for compensation to still be owed to the buyer's broker.
Yeah, can I caveat off onto a side note here for just a second?
Yeah.
I've heard a lot of people say, I don't like that. I don't like that the buyer can terminate this agreement. That's kind of like saying you don't like tuna salad until you have a tuna salad sandwich for lunch and you really like it, right? That agreement clause exists for both parties. That agreement is so that you can terminate it if you don't want to work with that buyer anymore and you can be out. And it exists so that if they terminate it, you can document what properties you believe you've introduced them to that they're going to owe you commission on within that 3-day period of time. to better protect yourself going forward. So don't be scared. What I would say is don't be scared at all about that termination agreement.
Yeah, I agree with that. Will, any more before we go forward?
I think last one on this, and I'll let you guys get back to your regularly scheduled program. Something about, I'm in my mind thinking of it dual commission, but if a buyer understands that the seller is offering compensation and the buyer is still willing to get additional compensation, the buyer is willing to provide additional compensation, can you be compensated from both parties? If so, do they add together, or is there a maximum involved? How does it work when kind of both sides of the transaction are contributing to the buyer representative's commission?
Yeah, no, I'll jump in on that if that's
Yeah,
all right,
right.
Hutch. So yeah, again, at baseline here, under the buyer broker agreement from OREC, it absolutely contemplates situations where compensation to the buyer broker can be paid by both parties. One of the specific example that I'm thinking of is, imagine a situation where the seller's offer of compensation to the buyer's broker or for buyer broker services is less than what the buyer's broker has agreed to accept from the buyer. There's a delta there in that situation, right, between what the buyer's agreed to pay and what the seller is offering. That language in the contract contemplates that difference would be paid by the buyer. So again, that's one example where OREC has recognized a situation where compensation to the buyer's broker is being paid both by the seller and by the buyer on the same transaction.
Completely agree. You can be paid by both parties. The kicker to it is, whatever that maximum amount is, that's the maximum total amount. The rest of it is negotiable, who pays how much and what.
Right, and as far as that maximum, remember, that's whatever is articulated in paragraph 7. So whatever that maximum threshold in there is, whether it's a flat fee or whether it's a percentage, whatever that amount is, you cannot go over that amount absent a specific written amendment or renegotiation with your buyer.
Yeah. So, all right, Jace, I'm gonna kick into a question for you. How does the buyer broker agreement work with like residential leases, for example?
Right. So we got a couple questions about this, and I just want to provide just a little bit of information here. You can look here in the first paragraph of the buyer broker agreement. It talks about the ability to use this in the context of a lease. It talks about substituting words, the fact that the seller shall mean landlord, the buyer shall mean tenant, gross selling price turning into total lease price, purchase agreement to lease agreement. So yes, you can use this agreement when you're working with a tenant on leasing a property. I would tell you also, though, that NAR's practice changes do not require you to enter into a written agreement with a tenant prior to showing them a property. That requirement to, again, have a written agreement, specifically spelling out compensation, et cetera, before showing, that applies to home purchases. It does not apply to leases.
All right, so I'm gonna follow up on that because to be very clear, the form allows you to use this for leases. You don't have to.
Correct.
But if you want to use it for a lease, you can do that to protect yourself and protect the consumer as well. One of the key words in this question I thought was residential. Does residential include a 5-unit apartment complex?
I would say yes.
A 5-unit apartment complex?
Oh, sorry, a 5. No.
No, it applies to 1 to 4.
1 to 4. Yep.
Family residential structures.
Correct. Yeah. Sorry.
So does it apply to agricultural property?
So as far as the NAR practice changes,
Yes.
sorry, the practice changes, no, they do not apply to agricultural property. So what I mean by that is, again, even if you're working with a purchaser, not someone who's leasing, if you get a purchaser who's wanting to purchase agricultural property, the terms of the settlement agreement specify it only applies to homes. And the guidance that we're hearing from NAR on that issue is that it does not apply to agricultural properties. And furthermore, if you think commercial, we've gotten a lot of questions on the commercial space as well. Those practice changes now, some of the other practice changes regarding removing commissions from the MLS, that obviously still applies to all listings, right? But as to whether or not a written agreement has to be entered into prior to showing, that would not apply to commercial.
Right. And I would add to that I think there is a caveat, a carve-out. So the settlement agreement contemplated single-family homes. That's what it was really about. It's transitioned to 1 to 4 family residential structures.
Mhm.
In Oklahoma, there is a caveat, I think, that needs to apply to that, because we have in Oklahoma what we would call a gentleman's farm. a 10 acre or 20 acre or 100 acre tract of property, 500 acre in some cases, tract of property, that's farmland, it's agricultural, but it has a single family residence on it.
Mhm.
If you have a client that is looking for that type of property, I would suggest a good practice would be utilizing a showing agreement, whether OREX or another one, that would be a good practice.
Absolutely.
If your client is specifically looking to buy a farm for farming purposes, regardless of whether it has residential property on it or not, you've got a better chance of being protected in that regard. But if you know that they're planning on occupying the residence on a farm, then you want to make sure that you're using that type of agreement. And that's a little different for here in Oklahoma than it is, perhaps in New York City.
It is. Our homestead exemption applies to very large swaths of land that people happen to live on. And so, yeah, if they're intending to make it their homestead, if they're intending to be domiciled there and reside there, that would probably be considered a home. And in light of that, would need to be covered with a written agreement prior to a showing.
Okay.
Yeah. So we've got one more here written down before we go to more live Q&A.
Okay.
And Hutch, is for you. What if a builder
I
is
knew you were
offering,
gonna ask me
yeah,
this
yeah,
question.
is offering a bonus? Let's say the bonus offered to a buyer's broker on a single transaction.
A bonus offered by a buyer, a cash bonus, a dollar bonus, or I guess anything, right? So if there's a contemplation of offer, of compensation, whether that's cash, whether that's, that bonus is, extra money, whether that bonus is a trip, just for selling that property, whether that bonus is that proverbial 1957 Mercedes 300 SL Goldwing, and that they're gonna give you for selling a single family house. It doesn't matter what it is, your compensation cannot exceed what you've agreed to. So let's say that there's a seller of a property, in this case being the builder, is offering a bonus of, I don't know, $5,000 plus 3%, and you've agreed to 3%, I'm just using arbitrary terms, then you're limited to that 3%. You're not limited to any bonus, because any bonus is a non-readily ascertainable dollar amount. So in the case where it's contingent on the sale of one property, no.
Yeah, absent.
Unless you clarified that, I should say, in your agreement. For example, you could, if you know you're showing new construction property and that a bonus may be possible, you might put compensation of X% plus any bonus up to Y amount for a performance bonus up to Y amount, or something to that agreement, but you would still need a cap on both sides.
Right, and if you, let's say you don't learn about the bonus until after the fact, again, let's say you just have a default, like whether that's a flat fee or a percentage, and you find out after the fact that there's a bonus being offered. As Hutch said, you can't accept more than what's stated in your agreement. And so if you find out about that after the fact, if you want to try to accept that bonus, that is going to be something that you have to work out with your buyer on the front end through an amendment to that buyer broker agreement and the amount of compensation received. Follow-up question,
Okay.
does your analysis change at all if you have a bonus offered after several transactions have taken place? Let's say a particular buyer's broker has brought several people to a particular neighborhood, and the builder wants to recognize and to reward the buyer's broker in a setting like that.
You, Mr. and Mrs. Agent, you've sold 5 of my properties this year, therefore you qualify for this tiered bonus structure plan. Nuance question, right? And I think a lot of that's going to depend on how that is structured by the builder. And what I mean by that is if the contemplation is solely because you've sold the property, then it is therefore a bonus for the sale of the property and is therefore compensation based on those specific transactions. And so to accept those, I would think on the very last one that qualified you for it, you would have to have that conversation with the buyer and say, hey, this is my 5th house, well, then they're going to offer me a bonus. I need to include this on the agreement and have that conversation. However, most builders that I know that have done tiered type of things like that already structure it differently. They already structure it now where it's not a bonus because you've sold that many properties, but rather because you've sold that many properties, they are inviting you to do a trip or something like that where they are previewing as part of that trip, their new properties, the new products that they're bringing out, those kind of things. I think that will be dealt with differently, because I believe that's really a different intent. That's really about selling that agent on the benefits of building with that building downstream. And that's a different contemplation. They're looking for high producers, people who are loyal to them so that they can keep them loyal, keep them working forward. I think that's a different contemplation. Jace, what do you think about that? I mean,
Yeah, I think it's a nuanced question, and it's probably the most nuanced question that we've asked, that we're.
I would agree with that.
Today,
Yeah.
and in light of that, I would just say that given the nuance, where nuance exists, I find that litigation follows. And so that may well be an issue that gets litigated someday. My best advice at this point is that every broker is going to have a different appetite for risk regarding that type of arrangement. And so if you're an agent, man, you double check everything with your broker. And if you're a broker, again, that's a business decision for you to weigh as far as what you'd like to engage in, where you're comfortable, where you're not. That'd be my advice.
Yeah, I think what's sitting me right now is as we're talking through this, again, for the probably 15th or 20th time that we've talked through this topic. What really sits with me right now is, how does it feel? If you're asking yourself the question if it's right or wrong, then you should probably err on the side of caution and be as transparent as you possibly can. That would probably be the best practice, whether the legal standard or not. That's probably going to be the best practice. Is if you're asking yourself, do I need to even disclose this? Then it's probably something that you should be disclosing. I think that's probably a fair answer to that question.
I would agree with that. As a baseline principle, over disclose. The intent behind this is not for anyone in a transaction like this to hide the ball in any way, shape, or form. So again, if the conviction arises and you feel that I might ought to disclose something, I generally recommend disclosing in those instances.
Yeah. And by the way, and when in doubt, ask your broker, because your broker is ultimately going to be the one who is on the hook. For those of you who are brokers, might think through that policy ahead of time and make sure you've explained it, your policy to your agents clearly. Will, what other questions do we have?
All right, a big one we've got in here several times, and with August 17th being, very soon from now, coming up this weekend, what do we do about our existing listings out there? Is there an addendum we need to attach? Do we need to redo our listings? What changes for those business real estate relationships we already have existing?
I've been asked this question multiple times at multiple venues. My answer may be different than your broker's answer or your local MLS's answer. My answer has been, you really don't need to, you're not required to do anything. But as you, on the 17th, as you start representing buyers, you most certainly need to be entering into this agreement. So if you are currently working with buyers and you're in the middle of working with buyers, hopefully you've already started using the buyer's agency agreement a few months ago. So that you're used to it. But on August 17th, if you're working with a buyer, before you go out to show those properties, you've got to sign the agreement. For those of you on the listing side, nothing has changed for the listing side. Cooperative compensation is still allowable. If I'm representing somebody and they've offered cooperative compensation, I'm not opening that back up unless they bring it up to have the conversation. I'm going to deal with that at the time that an offer comes forward. And if I receive an offer that potentially saves my seller some money or gives them advantage, I'm absolutely going to make sure they understand about that. But I'm not aware of any requirement to change listing forms after listing agreements after August 17th. Jace?
Yeah, the only thing that I would add on that is that I do think there might, I'd have to double check the language. It's a large settlement agreement, folks. That in order to offer cooperative compensation on the listing broker side, or from the listing broker to the buyer's broker, there has to be authorization from the seller to do so. So long as your listing agreement that you have in place when August 17 rolls around, if it contains an authorization and it spells out like the language that's in the OREC listing agreement right now, how that money will be split out in the event of a cooperative compensation agreement, that should satisfy that. But if you're operating in the context of a listing agreement, which doesn't have that language, recommendation would be, and best practice would be to get that up to date. But I suspect that a lot of folks are already up to date with the new form that came out from REC.
One we've seen a couple of, guys, is people asking about, what if you have an agent show a home to your client for you? Do they need to sign a buyer agreement with that agent who's showing them the home on your behalf? Or if you're voluntarily helping out somebody at their open house, is there anything you need to do with the buyer broker agreement at the open house? I guess that's two questions. Sorry.
Yeah, and I think that those two questions really are a catalyst of probably 15 or 20 different scenarios. Obviously, we can't cover all the scenarios here, so let me cover two. A brokerage firm has a property listed and agent A is the primary listing agent assigned to that property. And they want to get agent B, agent C, or agent D from the same brokerage to hold open houses in that property. At that point in time, those agents work for the broker owns the listing, so it is the same as if the actual listing agent has listed the property. In other words, just because I'm not there, if somebody from my office is the one doing that, they can show that property on behalf of the seller, because that seller has hired the brokerage firm. Small caveat, unless you're working in a team structure that has different listing agreements that specify different things, but that would be incredibly nuanced. If that agent, however, is from a different brokerage firm, and the contemplation is that they're showing that property on the open house because they hope to obtain a buyer from it, then that buyer, that agent most probably should have some type of agreement in place, form readily available for people coming in, because they may not find the same level of protection through insurances because they are doing it with a different intent. When you work for the same brokerage firm, the intent is to represent the seller and get the property sold. When you're doing it from a different brokerage firm, unless the listing broker is paying you and directly compensating you for that action of showing the property, and you are therefore under contractual agreement to work for them, you're working with the anticipation of getting a buyer and making some money, and finding somebody that's going to come in that you can represent to work that property. In other words, you're using that property as an advertising vessel to obtain buyers. Once you've obtained that buyer, i.e. they've walked in the door, you need to solidify that. Jace?
Yeah, absolutely. So the trigger again, under the settlement agreement is working with. Okay, so if you're in that situation and you're showing a house for the listing broker, but you work at a different brokerage, man, if someone comes in the door and they start looking to you for any sort of representation or advice or anything like that, you just need to be pretty clear that you need to step outside of the house and write something up, even if it's a short-term touring agreement or something like that. Get something in writing in place before you go back to touring the home, just so that you can again maintain the protection that NAR bargained for our members under the settlement agreement.
Yeah.
Let's not do anything that could forfeit that.
Yeah, I'm gonna add on to that real quick, as we're taking this live, I'm processing through. I was actually in a discussion with a real estate broker that I believe was in Utah, not Oklahoma. I believe they're in Utah. And what this broker was expressing to me that they were going to do is have those pull-up banners made, clear and conspicuous, with language on it that said, "Thank you for touring this open house. Please note, all licensed real estate agents work for the seller of the property unless otherwise disclosed in writing or agreed to in writing." Something like that. It was they're gonna use a pull-up banner and just set it in the foyer of the house. I thought to myself, what a great idea. Make it clear, make it readily transparent to the people coming in. We work for the seller. If you need representation, we're glad to represent you. I thought that was a great idea. Might be something you wanna, our members wanna try to implement themselves.
Yeah, absolutely. Will, any other questions?
I got three, I think, rapid fire ones for you that deal with our association and the relationship with the buyer broker agreement here a little bit. A lot of questions folks are asking out there, I'm sure, and asking each other. We expect buyers to need a little bit of education in this process, probably. What happens when a buyer signs two brokerage agreements, and doesn't inform the other parties? How is that going to be mediated, inevitably when they buy something and one party is left out?
So the buyer's agency agreement contemplated that. Part of this buyer's agency agreement is that buyer is certifying they are not under representation. If somebody fictitiously enters into a contract, with another, one party enters into a contract fraudulently with another party, there's recourse under the law for that. And it's really that simple. By the way, not to overstate it, I've heard people worried about that, and my response is this is better protection than you have today. Because when you don't use buyer's agency agreements today, this is a common practice. A buyer shops different properties, calls 5 or 10 different agents until they get somebody that shows in the house. Everybody thinks they're representing them until that buyer uses somebody else that you've never even heard of before. So this agreement, the OREC agreement contemplates it. And it has an affidavit that says that the buyer is certifying they're not working with other people. There's recourse under the law to be made whole.
Yeah, and to the extent you do have a buyer that's entered into 2 of these agreements with different brokerages. I think the question also contemplated that kind of the second part of it was what happens when there arises a dispute between those 2 brokerages over who's entitled to any cooperative compensation that may have been offered. I would tell you that again, you've got, if you have any sort of commission or compensation dispute between 2 different brokerages, that's subject to mandatory arbitration here at OAR. We would facilitate a mediation of that type of a dispute. And again, resolving those type of procuring cause disputes is absolutely going to be part and practice what we continue to do here at OAR.
About the settlement in general, does this apply to all licensees in Oklahoma or only realtors? And therefore buyer broker agency agreements?
The settlement, the NAR settlement, applies to all of those members of the National Association of Realtors who have opted in. Whether they've opted in, the brokers opted in, the MLSs they work for opted in. That's who the settlement agreement applies to. If you are not a member of the National Association of Realtors, the settlement agreement neither applies to them, nor does it afford them the protection under the law. And those will be, those agents will most probably face the litigation on their own.
Yeah.
Do those agents, have to use the buyer broker agreement then, or what other legal recourse do they have to do to represent people?
Currently, as of August 17th, or August 15th, they do not have to use this buyer broker agreement. We do believe that in the state of Oklahoma, probably beginning in early 2025, all licensees will have to use some type of memorialized agreement prior to engaging in residential transaction, both on the buy and the sell side.
Yeah, I agree with that. Yeah, so again, in the settlement agreement, as far as what is required of realtors, it's to have that written agreement in place beginning August 17th. To Hutch's point, we expect that to be broadened to all licensees eventually in the near future. One quick plug really quick on who's covered by the settlement agreement. I believe you must be a member of the National Association of Realtors on the date of class notice. And I know that we are expecting that imminently, probably within the next week when class notice goes out. So if you're an active member at that time, that's the trigger for being covered automatically as an individual member.
Yeah.
There can be a different question that has to be asked if it was a very large broker that had more than 2 billion in sales in the year 2022, as far as opting in, but brokerages smaller than that automatically covered. Individual members automatically covered.
Yeah, and it is also fair to say, by the way, not a scare tactic, but that coverage dissipates if someone is no longer a member of the National Association of Realtors. So in the case where they let their membership lapse or they choose not to rejoin NAR, that coverage goes away in hindsight, retrospectively. The coverage there, in other words, they are no longer covered. They by losing membership, they have lost coverage, and so that also should be contemplated. That's another one of those, I hate the word nuance, we've used it a lot, Jace, but it's one of the side things I don't think people really understand is how much value there is in that coverage from all of the individual lawsuits that will now come following this settlement agreement.
Right.
Once the settlement is actually signed off, full force and effect by the judgment, how many of the secondary lawsuits are there gonna come forward out of, for non-covered,
Right.
non-covered people?
Right, I agree.
Sorry, Will, go ahead. All right, hearing no more questions from Will, we did promise that we would be done within the hour. So I just want to say thank you for letting us serve you here at Oklahoma Realtors. We truly believe that the ability to buy, sell, and lease property is paramount to the safety and security of every community, every city, every municipality, every county in the great state of Oklahoma. And we're committed to helping our members be able to do that. We have a legal line for you. If you have follow-up questions, you can send email to the legal line. You can find that at okrealtors.com. The National Association of Realtors has a fax page. That fax page has over 150 frequently asked questions and answers to it. So many of the questions you're asking yourself, you can find answers there. About the form specifically, you can reach out to us, to your local association, MLS, or to OREC. They're glad to have that conversation with you as well. Although we love to share that burden with them and help you. We think we can probably provide you answers faster. Among that, we just want to encourage you, don't be weary. Look at the opportunity that lies before us, the opportunity to get better, to be more professional, to do a better job of serving our clients, and to find greater ways of entering into prosperity through sales. We appreciate you, and we look forward to the next time we gather together. Thank you.
Thank you.